Okay, let's be honest. Legal stuff, right. It can feel like you're wandering in a fog, trying to figure it all out. Rules and regulations, all kinds of lawyers. And then how are you even supposed to pay for it? It gets confusing really fast.
Yeah.
And that's exactly why we're tackling this today. Welcome to the deep dive. We're diving deep so you don't have to.
Yeah, you said it. We're taking on the whole structure and regulation of legal services today. We've got this really in-depth document called, well, just 7 legal services. It's updated as of last September, so 2023. It's basically like your cheat sheet to this whole world.
Exactly. Our goal today, which you're already in on, is to pull out the most important things from this document. We'll be explaining who all the main players are, what they actually do, and hopefully we'll uncover some stuff about the legal industry and its oversight that you didn't know. All in a way that actually makes sense. All right, let's start unpacking all this. Where do we even begin with such a complex topic?
Well, the logical place to start is with the basics. What are we even talking about when we say legal services? At its core, it's qualified professionals, think solicitors, barristers, using their legal knowledge for, well, pretty much anyone, individuals, businesses, even the government.
Okay, so it's more than just those dramatic courtroom moments you see on TV. What kinds of real-world services are we talking about?
Oh, there's a whole bunch. First, you've got just plain consultation, like getting legal advice. Then there's representation, where a lawyer actually acts on your behalf.
Yeah.
Document preparation is another big one, contracts, wills, things like that. And of course, there's negotiation, trying to work things out outside of court. Then we've got, the actual litigation, court cases and all that. But it also covers things like alternative dispute resolution. So, mediation, arbitration. Oh, and regulatory compliance, helping businesses make sure they're playing by all the legal rules.
So it's a pretty wide spectrum. Why are these services so important in the grand scheme of things?
They're essential, really. They make sure everyone has access to justice, upholding the rule of law, making sure people's rights are enforced and disagreements get settled fairly. They even help keep society stable because they give us ways to resolve conflicts. And they play a role in economic development, too, making sure businesses can operate smoothly and everyone knows what the rules are.
So they're not just a necessary evil, but actually make society work? What are some concrete examples of the roles they play?
Well, think about social justice, right? Legal services can help marginalized groups get representation and fight for equal rights. And on the economic side, like we said, they help businesses function, they explain those complicated regulations, and that makes a more predictable, stable environment for everyone. Even good governance relies on legal services because you need them to make sure the laws are applied fairly and consistently. And legal professionals often end up educating the public about their rights, which means people are more aware and understand the law better.
It all connects, doesn't it? So who are the ones actually providing these services? What does the legal services industry look like, the structure of it?
Let's see. There are several main players. Law firms are the first thing that comes to mind, obviously. Some are small and really focused on one area, and some of these huge international operations with offices all over the place. Then you've got solo practitioners who are independent lawyers, often experts in a very specific niche, in-house counsel, the lawyers employed directly by big companies and organizations. Legal aid services, super important for people who can't afford a lawyer. Those are usually run by the government or nonprofits. And we can't forget the regulatory bodies, like the Solicitors Regulation Authority, the SRA, who keep an eye on all these legal professionals. Oh, and lately, there's been a boom in legal tech companies. They offer online services, making documents or giving basic legal advice.
Wow, that's a real mix of players, from your classic law firm to these tech startups trying to shake things up. You mentioned the SRA. They sound pretty important. What's their role?
Yeah, they're a major player, definitely. They're all about upholding the rule of law, making sure the public actually trusts legal professionals, and making sure solicitors act independently, honestly, with integrity. They also really push for equality, diversity, inclusion in the profession. But the bottom line for them is making sure solicitors act in their client's best interest. Always.
Sounds like a big job. How do they make sure everyone's following those principles?
Well, they use what they call risk-based regulation. They can't possibly keep an eye on every single solicitor, every single law firm all the time, right? So they have to be smart about it. They figure out where the biggest risks are, where things are most likely to go wrong, and they focus their resources there. Makes sense, right?
Yeah.
That way they can best meet their main goals. High standards, protecting the public, and making sure justice is done.
Sounds like a smart approach. So I saw something in here about reserved legal activities. That sounds intriguing and maybe a little scary. What are those all about?
Ah, yes. So those are very specific activities that legally you have to be authorized to do. They're in Section 12 of the Legal Services Act of 2007. It's like the core of what legal professionals do. Like, you need a special license to operate heavy machinery, right? Same idea.
Right. So what kinds of activities are we talking about here?
Well, first, there's the exercise of a right of audience. That basically means you can appear and speak in court for someone else. You can question witnesses, present arguments, all that. Then there's the conduct of litigation. That covers starting court proceedings, prosecuting or defending a case, and all the procedural stuff that goes along with it. Then we have reserved instrument activities. That's about preparing and filing legal documents for things like transferring land, handling estates, or court stuff, though some things are excluded, like wills and powers of attorney. Oh, and then there's probate activities. That's all the work involved in handling someone's estate after they pass away. We also have notarial activities. That involves certifying and authenticating documents for international use. Traditionally, this was all done by public notaries under the Public Notaries Act way back in 1801. And finally, there's the administration of oaths. So the power to swear someone in. Think about it. If someone unqualified tried to swear in a witness in court, it'd be chaos. That's why it's reserved.
That's a pretty serious list. So where does the SRA come in with all these reserved activities?
So the Legal Services Board, the LSB, was created by that 2007 Act. They're the big boss, overseeing all the approved regulators for legal professionals. And that includes the SRA for solicitors in England and Wales. The SRA's job is to make sure the training and admission of new solicitors is up to par and to regulate those who are already practicing. It all comes down to protecting the public. They have to ensure that all these solicitors are competent, they're ethical, and they can step in if there's any risk to the public. Interestingly, the SRA board itself is made up of both solicitors and regular people, 5 solicitors and 6 lay members, as they call them. That mix is supposed to make sure both professional and public interests are considered.
That mix of regular folks on the board sounds like a good idea. So how do firms and individual solicitors actually get permission to do these reserved activities? I saw firm-based authorization and authorization of individuals in here. Let's start with firms.
Right, so for firms to get authorized, the SRA has a bunch of criteria, depending on how the firm's structured. There are recognized sole practices, where one solicitor owns and runs the whole show. Then you've got recognized bodies, where most of the managers and owners are qualified legal folks, and at least one of the managers has to be a solicitor. And then there's licensed bodies, which are also called alternative business structures, ABSs. Those are interesting because, unlike traditional firms, they can have owners or people in charge who aren't lawyers at all. But they have to have at least one manager who's authorized by the SRA, and they need to fit the legal definition of a licensable body. ABSs have really changed things up in the legal world.
So someone who isn't a lawyer can actually have a stake in a legal business under this ABS setup. That's pretty different from how things used to be. What happens when a firm gets this authorization? What does it actually mean for them?
Once a firm gets the thumbs up from the SRA, whether they're a sole practice, a recognized body, or a licensed body, they can officially do all those reserved activities we talked about. Plus, they can offer immigration services. It's what separates them from the firms that can't offer those core legal services.
Okay, so it's like getting your official license to operate. What's involved in getting that authorization? Is it just filling out a form and hoping for the best?
It's a bit more involved. First, they have to submit a formal application to the SRA. But the SRA doesn't just automatically approve everyone who applies. They go through the application and make sure the firm actually meets all the basic requirements. And then the important part, they investigate. They really dig into the applicant firm, to make sure they can be trusted with the authority to handle those reserved activities. And like we talked about earlier, with the risk-based approach, how much they investigate depends on how risky they think the firm is. A brand new firm will probably get more scrutiny than one that's been around for ages and has a spotless record.
Makes sense, but it's not one size fits all. Now, what about individual solicitors? How do they get authorized?
Right, so the SRA sets the bar for all solicitors in England and Wales. They're the gatekeepers. They want to make sure that anyone who wants to be a solicitor actually has the legal knowledge, the skills to use that knowledge, and that they're honest, have integrity, and are ethical. So to actually be admitted as a solicitor, you have to prove to the SRA that you've done the required education and training. And they don't just look at your grades. They do background checks too, making sure your character and your overall suitability for the profession are up to snuff.
So it's about the whole package, not just passing exams. And once someone's admitted, can they just start practicing law?
Not quite. After you're officially admitted, you need what's called a practicing certificate, a PC. That's your ticket to actually start working as a solicitor. You can apply for it at the same time as you apply for admission or later on. Oh, and there's an ongoing requirement that you have to be proficient in English or Welsh, both written and spoken. How they check that used to depend on how you qualified, but with the new solicitor's qualifying examination, the SQE, they're trying to standardize everything. Generally, if you qualify through the normal route, which includes the SQE, they figure you're good on the language front.
Ah, the SQE, that's the big change in how solicitors are trained these days. So the document mentions solicitors working outside the usual authorized firms. What's up with that?
Yeah, there are a few different ways that can happen. You've got your freelance solicitors.
Mm-hmm.
They work for themselves, which means they're personally liable for everything. The SRA has rules for them, of course. They have to have adequate and appropriate professional indemnity insurance, especially if they're doing any of those reserved activities. Then you've got in-house solicitors. They work directly for organizations that aren't regulated as legal businesses. Could be companies, charities, local governments. The key thing is these solicitors are qualified lawyers, but their organizations don't have to follow the same rules as law firms.
So an in-house lawyer for, say, a big company isn't part of an SRE-regulated firm.
Right. Then you've got your non-commercial organizations, like charities or unions. They're usually exempt from SRA authorization. Their solicitors can handle reserved activities, but only for the organization itself, not for the public. And their insurance has to be good enough to cover it all, of course. The SRA keeps an eye on that. And lastly, a solicitor could be working for a commercial organization that isn't regulated by the SRA. They can do non-reserved legal stuff for the public, but they absolutely can't do any of those reserved activities. Keeps those core activities within a controlled, regulated environment.
Makes sense. So insurance is a big deal here. I see professional indemnity insurance mentioned a lot. Why is that so important in the legal world?
It's crucial, really. Two main reasons. First, it protects the solicitor themselves. If someone sues them, claims they messed up or gave bad advice, this insurance can help cover the costs. Second, it protects the client. It makes sure that if a solicitor does make a mistake and the client loses money, there's a way for them to get compensation. Without it, if a client suffered because of a solicitor's error, they might have no way to recover their losses.
So it's a safety net for everyone. What rules does the SRA have about this insurance?
They've got the SRA indemnity insurance rules, which set the minimum standards. Now, these rules don't cover assistants or trainees directly because they're usually covered under the firm's insurance. But freelance solicitors, those working in non-commercial bodies doing reserved activities, and solicitors in unregulated places doing non-reserved stuff for the public, they all have to have this insurance. The Law Society used to run a central insurance program, but now firms and individuals have to get their insurance from companies that are SRA approved. And if a firm somehow isn't insured and the client makes a valid claim, the SRA Compensation Fund might step in as a last resort to protect the public.
A lot of layers there to make sure everyone's covered. Solicitors aren't the only legal professionals, though, right? The document mentions other regulated providers. Who else is out there?
Oh, there's a whole range of specialists. You've got your barristers, of course, famous for arguing in court and giving expert advice. Chartered accountants get involved, too, with financial stuff and auditing, which can overlap with legal issues. Then you have chartered legal executives. They're authorized lawyers, often specializing in a particular area of law, and they can do some reserved work, too. Costs lawyers are the experts on legal costs. They can even go to court for those issues. Licensed conveyancers, they're all about property law, buying and selling. Notaries, they're qualified lawyers appointed by the Archbishop of Canterbury himself, and they certify documents for use internationally. And finally, you've got your patent attorneys and trademark attorneys, the intellectual property specialists, all about patents, trademarks, that kind of thing.
It's like a whole legal ecosystem. Are they all regulated under that 2007 Legal Services Act?
Well, the Legal Services Act of 2007 laid the groundwork, created the Legal Services Board to be the main overseer, but a lot of these professions have their own historical regulatory bodies and laws that are specific to what they do. Barristers in England and Wales, for example, they're mainly regulated by the Bar Council. So, yeah, the 2007 Act tries to unify things, but each area still has its own detailed rules.
Okay, that makes sense. Now, what about regulation outside the Legal Services Act 2007? What's that about?
Right, so those are providers who offer services that might touch on legal issues, but aren't regulated by the same system set up by the 2007 Act. For example, claims management companies, they're regulated by the Financial Conduct Authority now because of the financial side of their work. Immigration advisors, they help with immigration stuff and are regulated by the Office of the Immigration Services Commissioner, a special body just for that.
Mm.
And insolvency practitioners, they handle bankruptcies and stuff, and they're overseen by the Insolvency Practitioners Association, among others. Each area has its own specific rules tailored to the risks and what consumers need in that area.
So it depends on what they're actually doing and what the risks are. Last one in this section, unregulated providers. That sounds a little risky. Who are these guys and what's the downside of using them?
Basically, they're individuals or companies offering legal services without being overseen by any official regulatory body, like the SRA or the Bar Standards Board. They might help with things like making basic legal documents, but it's the buyer beware situation, really. There's no guarantee of quality, and if something goes wrong, it's tough to hold them accountable. The Legal Services Board, the LSB, they're the big boss, remember? They keep a close eye on these unregulated folks because they can still mess things up, even if they're not officially part of the system. The LSB wants to ensure access to justice, fair competition, and consumer protection. They've noticed a lot of these unregulated providers in areas like writing wills, handling estates, family law stuff like divorce, and intellectual property. That's where consumers are most vulnerable. The LSB tries to manage the risks by figuring out what could go wrong, setting clear expectations, doing checks to make sure the quality's okay, addressing specific concerns, and if they have to, taking action to protect people. But yeah, with unregulated providers, there's just no guarantee of quality or a clear way to complain like you have with regulated professionals.
So saving a few bucks might come back to bite you later. Okay, we've covered the basic structure and the main regulators. Let's move on to something that might not be the first thing you think about with solicitors. Financial services regulation. Why is this relevant to them?
Well, sometimes solicitors, as part of their work, end up doing things that are covered by financial services laws. The big one here is the Financial Services and Markets Act of 2000, or FSMA 2000. It's been updated since then, most notably by the Financial Services Act of 2012. It's a huge framework that covers tons of financial services and markets in the UK, and it's even more detailed with all the secondary legislation from the Treasury.
So it's not just about managing money in their client accounts. What sorts of activities might trigger these financial regulations for a solicitor?
Could be a bunch of things. They might give advice on investments as part of a bigger deal, maybe arrange investments for clients, like during a company takeover. They might even hold and manage client money that's specifically for investments, not just for fees or expenses. The main thing is to understand the structure that FSMA 2000 sets up. It created two big regulatory bodies, the Financial Conduct Authority, or FCA, and the Prudential Regulation Authority, the PRA.
Ah, the FCA and PRA, I've heard of them. What do they each do?
So the FCA is like the watchdog for how firms behave. They inherited most of the market regulation from the old Financial Services Authority. They're responsible for making sure all regulated firms, including solicitors doing financial stuff, conduct their business properly. They also regulate the financial health of firms that aren't covered by the PRA. Their main goals are to protect consumers, keep the UK financial system stable and honest, and make sure there's healthy competition that benefits consumers. Interestingly, the FCA and the PRA share some regulatory principles that are set out in FSMA 2000, specifically in Section 3B. These principles guide how they approach regulation. The FCA has some pretty strong powers, too. They can force firms to take down misleading financial ads, and they can block or stop services or products that they think are harmful to consumers. They also took over regulating consumer credit and second charge mortgages in 2014. Oh, and they started regulating LIBOR, the London Interbank Offered Rate, in 2013, although LIBOR was supposed to be phased out after 2021.
LIBOR, yeah, that brings back memories. Not all good ones. So the FCA has a lot on its plate. What about the PRA?
The PRA is focused on making sure the whole financial system is sound. They're a part of the Bank of England. They authorize and supervise firms that are dealing with big financial risks, like banks, building societies, insurance companies, and certain investment firms. These firms are either PRA authorized or dual regulated because the PRA oversees their financial stability, but the FCA still regulates their conduct. The PRA mainly cares about keeping the financial system safe and preventing things from collapsing.
Okay, so the FCA is the behavior police and the PRA is the stability expert. Got it. So how does all this apply to solicitors? Do they usually need to get authorization from the FCA directly?
Generally, if a business does anything that's considered a regulated activity under FSMA 2000, they have to be authorized by the FCA. Unless they have an exemption, of course. Section 19 of FSMA 2000 has what they call the general prohibition. You can't do a regulated activity in the UK without the right authorization or an exemption. But luckily for solicitors, there's this really important part of FSMA 2000 in Section 327. It's an exemption for professional firms like solicitors who might do some regulated activities as part of their normal work, but whose main business isn't about investments. To get this exemption, they have to meet some pretty strict conditions. The main one is that the regulated activity has to be a side effect of the normal legal services they're providing, and they have to be regulated by a designated professional body, a DPB. The SRA is recognized as a DPB for solicitors, which means they can do some financial things without going directly to the FCA.
That's a pretty important exemption. So what are the big things solicitors need to watch out for in terms of needing financial services authority?
There are two main things they always have to keep in mind. First, doing something that's considered a regulated activity, and second, making a financial promotion. We talked about the general prohibition in Section 19 of FSMA 2000, which says you can't carry out a regulated activity without being authorized or exempt. Section 21 of FSMA 2000 is similar, but it's about financial promotions. You can't make one unless you're authorized or exempt. Breaking these rules is serious business. You could be committing a crime, and if you break Section 19, any agreement you made because of that unauthorized activity might not be enforceable in court. So solicitors really need to know where the line is and what they can do without needing that direct FCA authorization.
Definitely sounds like knowing the rules is key here. So how do they figure out what's a regulated activity and what's a financial promotion in their work?
There's a four-step test to figure out if something is a regulated activity. First, is the person doing it by way of business? Second, is it one of the specified activities listed in the regulations? Third, does it involve a specified investment, or giving information about someone's finances or a specific benchmark? And finally, even if it meets the first three, is there an exclusion that applies? What counts as a specified investment and a specified activity is all spelled out in the Financial Services and Markets Act 2000, regulated activities. Order 2001, which is usually called RAO 2001. Specified investments cover things like company stocks and shares, but not those in open-ended investment companies or UK building societies. They include debentures, government securities, units in collective investment schemes like unit trusts and OEICs, contracts of insurance, certain mortgages, and even deposits. Although solicitors' money from clients is excluded, some things aren't usually considered specified investments like land ownership and some national savings products. Now, for specified activities, when they relate to these investments, they include things like buying and selling investments, arranging investment deals, managing investments for someone else, keeping investments safe, and giving advice about specific investments. It also covers stuff to do with setting up, running, and closing collective investment schemes and personal pension schemes.
A lot to keep track of. You mentioned exclusions too, right?
Yes, RAO 2001 has exclusions. Some that are particularly relevant to solicitors are the introducing exclusion, which applies when they just connect a client with an authorized financial firm. There's the exclusion for using an authorized third person to do a regulated activity. Then there's acting for an execution-only client, where the client makes their own investment choices without the solicitor's advice. Acting as a trustee or handling an estate also has an exclusion. And then there's the professional necessary exclusion for when a regulated activity is a necessary part of giving legal advice. Lastly, the takeover exclusion covers specific activities during mergers and acquisitions.
Right, and then there's that exemption for professional firms under Section 327 of FSMA 2000. What do solicitors' firms have to do to qualify for that?
There are a few key conditions. The firm can't get any secret financial benefits from anyone other than their client for the regulated activity. Second, that activity has to be a normal part of the legal services they're already regulated to provide by the SRA. Third, they can only do activities that the SRA specifically allows. Fourth, they can't do anything that's forbidden by the Treasury or the FCA. And lastly, they can't be doing any other regulated activities that aren't covered by this exemption. It's pretty detailed, so firms really need to be careful.
Definitely a lot to think about. All right, let's move on to another really important area. Money laundering regulations and the Proceeds of Crime Act. This sounds serious.
It is, definitely. Money laundering is how criminals try to make their dirty money look clean, hide where it came from. And unfortunately, criminals target solicitors to try to launder money through things like buying property or other legal services. The money laundering regulations 2017 are designed to stop this. They force professionals, including solicitors, to be proactive about spotting and preventing money laundering and terrorist financing. They specifically apply to independent legal professionals, which is most firms, and solo practitioners when they're providing legal or notarial services for financial or property transactions. It also covers a broad category of tax advisors, which can include people who help with tax stuff, even through a third party. So pretty much every solicitor's firm is covered. And here's the big thing. If you don't comply with these regulations, you're committing a crime.
Firms need to be super careful then. What are they required to do under these regulations?
A lot, actually. First, each firm has to do a complete risk assessment. They have to look at their own practice and figure out where the risks of money laundering and terrorist financing are. They need to consider their clients, where they do business, what kinds of transactions they handle. They even need to look at info from the Law Society and the SRA and national risk assessments. The current national assessment says things like trust and company formation, conveyancing, and handling client funds are high risk. This assessment has to be written down. That's Regulation 18. Second, firms have to create written policies, controls, and procedures that match the risks they've identified. Senior management has to approve these, of course. These documents need to cover everything: managing risks, due diligence on clients, reporting suspicious activity, keeping records, dealing with new technologies, and handling complex or unusual transactions. Third, they have to appoint a nominated officer, also called the Money Laundering Reporting Officer, or MLRO. The MLRO takes internal reports about suspected money laundering and talks to the National Crime Agency, the NCA, if external reports are needed. That's Regulation 21.3. They also have to pick someone from senior management who's responsible for making sure everyone follows the money laundering regulations. This could be the MLRO, if they're senior enough, or someone like the Compliance Officer for Legal Practice, or COLP, if they're high enough up. Regulation 21.1. They've got to thoroughly check their employees, too, looking at their skills, knowledge, behavior, integrity. This happens before they're hired and throughout their employment, especially for roles related to compliance and preventing money laundering. That's Regulation 21.1. Then, Regulation 21C says they need an independent audit function to check if their compliance policies are actually working, to suggest improvements and to monitor everything. Regulation 21.8 requires them to be able to answer any questions from law enforcement about their business relationships from the past 5 years, and to do it quickly. And lastly, there's a big one: client due diligence, or CDD. That's Regulation 27. They have to verify their clients' identities, with very few exceptions. This is mandatory when they start working with a new client, when they have occasional transactions over a certain amount, 1,000 euros for electronic transfers and 15,000 euros for other transactions if they suspect money laundering or terrorist financing, or if they have any doubts about the identity information they already have for a client.
Wow, that's a long list. What does client due diligence actually involve?
So CDD has a few different levels depending on the risk. Standard due diligence, which is Regulation 28, means firms have to check the client's identity using trustworthy sources. And if the client isn't a person, like a company, they have to understand who owns and controls it. Simplified due diligence, Regulation 37.3, is only for situations that are clearly very low risk, like dealing with a company listed on a major stock exchange. But just because something seems low risk doesn't automatically mean you can use simplified measures. Firms need proof, and they might still need info about the beneficial owners, even if the ID checks are easier, for example, just confirming a company's UK PLC listing. On the other hand, enhanced due diligence, which is Regulation 33, is mandatory for high-risk situations. This could be based on the firm's own risk assessment, info from the SRA or the Law Society, dealing with clients from high-risk countries, if a client gives fake ID when working with politically exposed persons or peeps on their families or close associates, or if the transactions are super complex, large, or don't have a clear legal or economic purpose. Other risky things could be unusual circumstances in the business relationship or payments from shady sources. And then there's Regulation 28.11, which says firms need to keep watching their business relationships. This means they have to check their clients' transactions to make sure they make sense, based on what the firm knows about the client, their business, and the risk level. If something seems fishy, they might need to investigate more or even do enhanced due diligence.
So it's not a one-and-done check, it's an ongoing thing. What else do they have to do under the money laundering regulations?
Training is another big one, Regulation 24. Firms need to train their employees and agents on the laws about money laundering and terrorist financing, data protection, and how to spot suspicious transactions. This training has to be regular, and they have to keep records of it. The Law Society suggests doing face-to-face sessions or online modules, and they recommend having a staff manual with all the AML policies. It's so important that not having proper training can actually be a defense if you're accused of breaking the Proceeds of Crime Act 2002. And lastly, there's Regulation 40, which is about record keeping. They have to keep detailed records of the due diligence they do on clients and full records of every transaction, either the originals or copies that are good enough to reconstruct what happened. They have to keep these records for at least 5 years after the relationship with the client ends or after the occasional transaction is done.
Okay, that covers the money laundering regulations. Now, what about the Proceeds of Crime Act 2002? How does that fit in with everything we just talked about?
Right. The Proceeds of Crime Act 2002, or POCA 2002, is how the UK fights money laundering on the international level. It lays out all the crimes related to money from criminal activity. It's obviously aimed at the people actually laundering money, but it can also create problems for professionals like solicitors who know or suspect something's going on and don't do anything about it. That's why solicitors have to be so careful and understand their responsibilities under both the money laundering regulations and POCA 2002.
So, what are the main crimes under POCA 2002 that solicitors need to know about?
There are a few big ones. One is arrangements under Section 328. This makes it a crime to get involved in something or even just know about something that helps someone else acquire, keep, use, or control money from crime. Arrangement is really broad, and it applies even if the money doesn't actually go through the solicitor's hands. You could get up to 14 years in prison for this. Then there's acquisition, use, or possession of criminal property under Section 329. This is about acquiring, using, or possessing money from crime. But solicitors have a possible defense here called adequate consideration. If they get paid a reasonable amount for their work and expenses and they didn't think the money was from or connected to crime when they got it, they might be okay. Still, you can get 14 years for this. Concealing criminal property, Section 327, is the classic money laundering crime. It's illegal to hide, disguise, convert, transfer, or move money from crime out of the UK. Because of the nature of legal work, especially with property and finances, solicitors can accidentally get caught up in this if they're not super careful. Then there's failure to disclose under Section 330. This one's specifically for people working in regulated sectors, which includes solicitors. If they know or suspect someone is laundering money, and they got that info